A very good morning to all of you students. I hope you all are very well. So today let's begin with new chapter of civics, that is chapter number 5, Judiciary. Students, before starting this chapter, I would like to say that we will cover this chapter in two parts. In part 1, we will talk about the introduction of this chapter, judicial reviews, law and fundamental rights, qualifications to become a judge in Supreme Court, how they can be removed or not, and the High Court. And in part 2, we will study about the subordinate courts and independence of judiciary, as well as we will also get to know about the Lok Adalats and public interest litigation, that is PIL. You must have heard that, okay? So without any delay, let's begin with part 1. So here on your screen, you can see that there is a image of, we all know this place. What is it called? It is the Honorable Supreme Court of India. Okay, let's move forward. Introduction of this chapter. The judiciary, it is very important. Means having judiciary in any country is very important. As well as if we are talking about India, we all know that India is a democratic nation and judiciary has important place, or we can say that it have important respect in our Indian society. We know that there is two kind of government in our India. First is the union government, in Hindi we call them as the Kendra Sarkar, and second is state government, that is Rajya Sarkar. They both work simultaneously or side by side, or they work together. Maybe the situation comes like in central government there is different party ruling, and in state there is different party ruling. But above this party scenario, they all work together for the nation interest. And if we talk about the constitution, how it has divided, it is divided the jurisdiction in three parts, or the three lists. First is the union list, second is the state list, and the third is the concurrent list. But there are chances, or there is a possibility of being disputes between center and state, between state to state, and if there is disputes between any, so here comes the important role of judiciary to handle and to sort out such situations. The Constitution of India, it says very clearly that the dispute between the state and the state, or dispute between any, must be resolved by the judiciary itself. If we talk about the other responsibility of judiciary, it is also responsible to check that, or to ensure that the rights of every citizen or every person residing in India is respected, as well as every person's right is being protected. And the government should not cross its limit. India has a single unified judicial system for all over the country. The Supreme Court is the top authority of the judicial system in India. There are many high court state-wise, and under high court there are many subordinate courts available in every state. What is the judicial review? As the final interpreter or the final decision maker of the Constitution, the judiciary has the power that it can strike down or take down the particular laws which is passed by the parliament, and when it can take down such laws, if they think or they believe that there are the violation of the basic structure of the Constitution. Means if there is any law passed by the parliament of our country, and if the judicial system thinks that this law is not as per the limit prescribed, or it is violating the structure. So the judicial can take down or they has the power to take down the law. And the above process which we have just discussed is known as judicial review. Now let's talk about the fundamental rights of India. Upholding the laws and enforcing fundamental rights. We know that every citizen in India can approach the Supreme Court or High Court or any court which is near to their reach if the citizen thinks that their fundamental rights has been violated, or they are not given the powers which the Constitution of India has prescribed to be given to every citizen. Let us understood by this example. If there is an agricultural laborer who fell down from a running train and he got injured during this scenario, and whose condition gone worse because every hospital or many hospitals refused to admit it. And when the Supreme Court heard this case, the Supreme Court told that the Article 21 or under Article 21, it's provide that every person has the fundamental right or the basic necessary right to life or to live, and it also includes the right to health. The court directed the West Bengal government to pay the labor a proper amount of compensation because the loss he has been suffered, as well as the court also ordered the government to come up or to prepare the blueprint of a primary health care with particular reference to treatment of patient during an emergency. It was a case related to Paschim Banga Khet Mazdoor Samiti versus the state of West Bengal. And the case was fought in 1996. Let's talk about the supreme authority of judiciary, which is the Supreme Court of India, Honorable Supreme Court. The Supreme Court is the apex, or is at the top of the Indian judiciary, and it was established by the Constitution itself. The Supreme Court have one Chief Justice and 25 other judges, and the number of judges can be changed, decreased or increased by Parliament as if when required. The Chief Justice of India and the other judges, these are appointed by the President of India, and the President, before appointing judges, he consults with other judges of the Supreme Court and High Court, and they discuss, and when the names are finalized, the President appoints those in the court. And if there is an appointment of other judges, means here other judges means other than the Chief Justice. So when there is an appointment of other judges, the Chief Justice of India is being always consulted. So here is the photograph of our current Chief Justice, who is named as Chief Justice of India, Shri S.A. Bobade, who is the 47th Chief Justice of the independent India. He is, in this photograph, he is taking the oath of his position, and he is been appointed. What are the various qualifications needed for appointment as a judge in the Supreme Court? First, he must be the citizen of India. Second, he must be the judge of High Court for at least 5 years, or he must have the working experience as an advocate in High Court for minimum of 10 years. Oath and term, Constitution of India and Article 124. The judges of the Supreme Court takes oath affirmation before entering upon the office. The oath is being taken by the judges of the Supreme Court in presence of the President of India. Or if the President of India is not available for the oath ceremony, then there is some person being appointed by the President of India for the same process. And once appointed as the judge, he can hold his office till he reaches the age of 25. Here in the image, you can see our current Chief Justice of India is taking oath in the presence of the President of India, Shri Ram Nath Kovind. Removal and emoluments. The judges of the Supreme Court can be removed only by a special procedure. And what is the special procedure? A judge can be removed by the President of India only when there is an impeachment is passed by the both houses of the Parliament. And in the same session, asking for his or her removal on the ground of proven misbehavior in incapacity. So, how the judge of the court is being removed? He can be removed by the President of India only when the both houses, Lok Sabha and Rajya Sabha in Parliament, they both passes the impeachment process against the judge, and the judge is proven and is been proved as misbehavior and incapacity to serve as the judge. Each house has to pass the address by majority. Means if there is a 2/3 majority seeking for the removal of the judge, then the judge can be removed. Judges of the Supreme Court addresses his running, and after when the judge is removed, so he sent his resignation to the President of India. Now, emoluments means salary and other incentives. The Chief Justice of India gets a monthly salary of around 1 lakh, and other judges gets 90,000, and they also receive many different allowance and other benefits. When the judges is serving in their office, they cannot be their benefits and salary cannot be reduced easily, and after retirement they cannot continue their practice in any court of law. What is the jurisdiction? The jurisdiction of the Supreme Court may be categorized as original, appellate and the advisory. Means three kinds of jurisdiction. Now, what is original jurisdiction? The Supreme Court has exclusive jurisdiction, or the Supreme Court can give decision on over disputes like between Government of India and one or more states. Second, between the Government of India and many other states on same or different side, or between two or more states. Appellate jurisdiction is what? That there are types of appeal which can be done in Supreme Court. First, there can be appeal against any decision or order of the High Court if the High Court gives a certificate that it involves some question of the interpretation of Constitution. Second, there can be appeal against any civil cases decided by the High Court itself. And the third, in criminal cases, there can be appeal in the Supreme Court if the decision made by the High Court is not being satisfied to either the accused or to the witness. Finally, the Supreme Court can allow any decision by the lower court to be continued. The Supreme Court can also review the judgment given by itself. The Supreme Court is also given the power under the Constitution to transfer a case from one court to another or to itself if it feels that there is an important question in the law it's been involved during the time. And the Parliament can confer the Supreme Court by powers by passing a law. What is now advisory jurisdiction? The Supreme Court also acts as an advisory jurisdiction, as it is the highest or apex court in the Indian country, and the Supreme Court can be consulted by the President on many process. If the President feels that there is an important legal question or any fact with the public, towards the public, and it is treated as important, and the same has been coming up or is expected to come in the near future, so the President can ask the advice on the matter with the Supreme Court, or it can discuss. The Supreme Court in such cases would consider it, and the Supreme Court can provide its opinion to the President. But the opinion given by the Supreme Court does not bind the President to follow it. A decision given by the Supreme Court has to be enforced by any or all the government authorities all over India. It means that whatever the Supreme Court has given the decision regarding any case, it has to be followed by every state government in India. The Supreme Court has power to protect the rights to constitutional remedies which the Constitution has given to citizens. And under this protection, if there is citizen feels that his or her basic fundamental rights have been taken away, or the rights of the citizen has been violated, then he or she can directly go to the Supreme Court. And the right to constitutional remedies empower the court to act as the guardian of the Constitution. Now, what is the court of record? The Supreme Court itself is the court of record, and all the decisions and proceeding of various different cases in the Supreme Court are kept as record and are quoted as precedent in the court. Means whatever the court, irrespective to the nature, whatever the cases, irrespective of the nature, every decision and proceedings is being recorded in Supreme Court. The court can punish for its own contempt if anybody does not abide its decision. So students, here comes the end of part 1. I hope you have understood it. Read the chapter and listen to this video carefully so that you can understand this part of chapter Judiciary very well. Thank you, and we will continue part 2 in the next video.